Let's be honest, dealing with a tax dispute is probably one of the most stressful things anyone can go through. You know, that brown envelope from HMRC drops on your doormat and your stomach just sinks. But here's the thing, you actually have more power than you might think. Challenging an HMRC decision isn't just a long shot, it's often successful. The real secret is knowing the process. And today, we're going to break it all down for you with a guide developed by the absolute experts at Pro Tax Accountant. I want you to just picture this for a second. Imagine you're a freelance graphic designer based in London. You've had a great year, you've worked your socks off, you filed your taxes, and you think everything's sorted. Then that letter arrives. It says there's been a mistake. You owe an extra £8,000. Your heart just drops, right? Panic starts to creep in. How are you going to pay it? Did you mess something up? This is a real scenario for thousands of people every single year. But what you do next in those first few moments is absolutely crucial. And that's exactly the journey we're going to walk through together. The specialists over at Pro Tax Accountant, well, they've seen it all. They've put together this incredibly clear step-by-step guide to help you navigate a dispute with HMRC. So, let's start with the most critical part of the whole process. The very moment you open that letter, an invisible clock starts ticking down. Seriously, this first phase is everything, and if you don't understand the deadlines, your case could be over before it even begins. Every single day counts. And here is that magic number, 30 days. From the date that's printed on that decision letter, you have just 30 days to formally challenge it. And let me be clear, this isn't a friendly suggestion. It's a hard legal deadline. If you miss it, your options shrink dramatically, and what was already an uphill battle becomes nearly impossible. So rule number 1, act fast. Now, what you actually do in those 30 days? Well, it depends on the kind of tax we're talking about. It's not a one-size-fits-all process. So, for direct taxes, think income tax or corporation tax, your first move is to appeal directly back to the very same caseworker who made the decision. If you can't agree, then they'll offer you a review. But for indirect taxes, like VAT, the path is different. That letter will offer you an internal review from the get-go. You can either take it, or you can decide to go straight to the tribunal. That's a big strategic call to make right at the start. And here's a massive pro tip that could be a total lifesaver for your bank account. That scary £8,000 demand. You can, and you absolutely should, formally ask HMRC to postpone the payment while you appeal. This isn't automatic, you have to specifically ask for it. Getting this sorted protects your cash flow while this whole thing plays out, which, as we're about to see, can take a while. Okay, so you've hit that 30-day deadline, you've lodged your challenge. Now let's talk about one of the most powerful tools you have, a step that so many people just skip over, the internal review. This is where so many cases are won. And here's something you really need to know. A review isn't just the same person taking a quick second look at their own work. No. It's done by a completely different officer, usually from HMRC's legal team, who's had nothing to do with your case before. Their job is to bring a fresh, impartial set of eyes to the whole thing. It's your first real shot at having a neutral party check out the situation. And if you're wondering, yeah, but does it actually work? The answer is a huge yes. Just look at these numbers. Based on projections for 2025-26, a staggering 62% of decisions that went to internal review were either canceled completely or changed in the taxpayer's favor. So this is no rubber stamp. It's a genuine chance to get a decision overturned. Okay, but I can hear you thinking, what if life just got in the way? What if you were ill or dealing with a family crisis and you missed that 30-day window? Is it all over? Well, not necessarily, but you're going to need what HMRC calls a reasonable excuse. So, what on earth is a reasonable excuse? Put simply, it's a real, provable reason for being late. It has to be something genuinely serious or unexpected that literally stopped you from acting on time. HMRC decides on a case-by-case basis, so the more proof you have, like a doctor's note, for example, the stronger your argument for a late appeal will be. So, what kind of things are we talking about here? Well, we're talking about serious life events, like a critical illness or the death of a close family member. But it could also be something practical, like your computer completely dying right as you were about to file, or major postal strikes you couldn't have seen coming. Just know that things like, I forgot, or the system was too confusing, well, those just aren't going to cut it. All right, let's say your case is a bit more complicated. It's not a simple mistake, there's a real disagreement over the facts. Before you start gearing up for a huge court battle, there's another route you can take. It's called Alternative Dispute Resolution, or ADR. Think of ADR like a facilitated chat. It's totally voluntary, and an impartial mediator from HMRC, again, someone new to the case, sits down with you and the original caseworker. Their goal isn't to pick a winner. It's to help both sides actually talk to each other and try to find some common ground. It's all about trying to fix this without the time, stress, and frankly, the cost of going to a tribunal. So when is ADR a really good idea? It's perfect for when things have just hit a wall. Maybe communication has totally broken down, or you fundamentally disagree on the facts. Perhaps you feel like HMRC just doesn't understand your business, or they won't explain why they rejected your evidence. ADR can really help cut through all that noise. But if even this doesn't work, well, then you're heading for the main event. So, if the internal review doesn't go your way and ADR isn't the right fit, you land at the final stage of the process. This is it. This is the main event, taking your case to the first-tier tribunal. Let's be crystal clear about this. The tribunal is an independent court of law. It has nothing to do with HMRC. This is where a judge will hear all the evidence from both you and HMRC, and then make a legally binding decision. It is a formal, serious process with strict rules. But don't worry, we can map out the journey so you know exactly what to expect. And wow, just look at this timeline. This is why I said you need to be ready for a marathon, not a sprint. After you file your appeal, it could be months before you even see HMRC's formal response. You might not exchange documents until month 7 or witness statements until month 10. The hearing itself could be almost 2 years away, and the final decision, well, that could take over 2.5 years from the day you started. This is a long haul. Now, the tribunal doesn't just throw every case into one big pile. They'll sort your appeal into one of 4 categories based on how difficult it is. Default paper cases are the simplest. Basic cases are for straightforward stuff. But most big disputes fall into standard or complex, and those involve way more formal legal steps. And here is another pro tip, and you really need to listen to this one because it has massive financial consequences. If your case gets labeled complex, the tribunal can order the loser to pay the winner's legal fees. This means if you lose, you could be on the hook for HMRC's legal bill, which can be huge. But you get a 28-day window to opt out of this. It's a massive decision. Opting out protects you if you lose, but it also means you can't get your costs back if you win. You absolutely need to discuss this with a tax expert. So the big question, what are your chances at the tribunal? Well, I'm going to be honest, this statistic for the 2025/26 period is pretty sobering. HMRC won, at least in part, in 93% of cases that went to the first-tier tribunal. Now, that doesn't mean you can't win. What it does mean is that your preparation has to be absolutely perfect. Your evidence, your arguments, your strategy, everything has to be watertight. This is not a game you play without professional help. Okay, deep breath. We have covered a ton of ground here, right? From that first scary letter all the way to a full tribunal hearing. It can feel like a lot. So let's just boil it all down into a clear, simple plan. What are the absolute key things you need to remember? Here it is, your HMRC appeals checklist. Number 1, act within 30 days. 2, immediately ask to postpone that tax payment. 3, always think about an internal review first. Remember, that's 62% success rate. 4, if it's a dispute about facts, look into ADR. 5, get all your paperwork organized from day 1. 6, if you do end up at a tribunal, prepare for the long haul. And finally, number 7, and this is probably the most important, for anything other than a super simple case, get professional advice. And of course, we have to say this, all the information we've talked about today is for general guidance. It's to help you understand the process. Every single tax situation is different, so you shouldn't rely only on this to make your financial decisions. You absolutely must talk to a qualified expert first. So what's the one thing you should take away from all of this? It's simple. Don't face this alone. Whether you're staring at that first £8,000 demand or getting ready for a tribunal, getting expert advice is everything. For help that's tailored exactly to your situation, you can reach out to the team at Pro Tax Accountant. You can see their details right there on the screen. Remember, knowing the path is the very first step to winning the journey.